rise. Please be seated for short and sound session. The Honorable United States Justice presents.
Thank you. You may be seated. Folks, I recognize we have a full courtroom this morning. And I know that the bulk of you are here for the matter of the people of the state of Michigan versus Brian Keeley. And I know that means that many of you have strong feelings and strong beliefs about this matter. With those come strong emotions. And so I'm asking you, if any of you experience those strong emotions, and they lead you to feel at any time overwhelmed, Sorry. We have a number of observers on Zoom, and I want to make sure that we are not getting any unnecessary feedback. So I'm asking if any of you are experiencing strong feelings or emotions that overwhelm you, that you please excuse yourself from the courtroom. It is very important that we do maintain decorum. If you are unable to do so on your own, court security may assist you in leaving the courtroom. At this time, the court is going to call People of the State of Michigan versus Brian William Keeley, case 24-60116FY. I understand Mr. Keeley is in custody.
Mr. Keeley is here with me.
Oh, he has been brought in already. Counsel, your appearance for the record.
Mark Curtis, honored to be here on behalf of Detective Sergeant Keeley.
And you are Mr. Keeley.
Yes, ma'am.
Welcome, Mr. Curtis. Welcome, Mr. Keeley. You may be seated. Mr. Keeley, in this matter, the people are alleging that on or around April 17th of 2024, in the city of Kentwood, county of Kent, state of Michigan, you committed the following offenses. Count 1, homicide, murder, second degree, upon one, Samuel DeJohn Cornelius Sterling, said act committed without premeditation or deliberation, contrary to MCL 750.317. That is a felony. It is punishable by life or any term of years. A consecutive sentence may be imposed for each death that resulted from operating a vehicle, and your DNA is taken upon arrest. They also allege count 2, homicide, manslaughter, involuntary, in that you did cause the death of Samuel DeJohn Cornelius Sterling by committing the following act or acts in a grossly negligent manner, to wit, the apprehension of Samuel DeJohn Cornelius Sterling, contrary to MCL 750.321. That is a felony. It is punishable by up to 15 years in the Department of Corrections and a fine of up to $7,500 with your DNA taken upon arrest, and a consecutive sentence may be imposed for each death that resulted from operating the vehicle. In these counts, felony in which a motor vehicle was used means a felony during the commission of which the individual convicted operated a motor vehicle and while operating the vehicle presented a real or potential harm to individuals or property. Do you understand those charges?
I do.
And do you feel as though you have had ample time to discuss your rights with Attorney Curtis?
I do.
Do you understand your rights?
I do.
Attorney Curtis, how is your client pleading at this time?
Not guilty to both charges, Your Honor.
The court will enter not guilty pleas in each of these counts, and we will schedule a probable cause conference and a preliminary examination. The purpose of those hearings is for the people to prove that there is probable cause to believe the felony offenses were committed and that you are the individual who committed them. Attorney Curtis, would you like to make argument for bond?
In regards to bond, Your Honor, Detective Sergeant Keeley turned himself in and has been cooperating with the investigation and also has been in contact with me almost on a daily basis. I have no concern that he is a flight risk. He is not. He's going to stand for the court and confront the charges. We're not concerned about him leaving the area. We're not concerned about him being a danger to the public, as in the fact that he was in the lawful performance of his duties at the time as a task force member. He isn't currently working as a trooper or Michigan State Police at this point, so there isn't any concern of him being in danger further to the public as to the operation of his duties. I would ask the court to consider all the facts and the fact that this is the first time one of the first times that he's been in legal trouble. He has an exemplary career as a trooper with the Michigan State Police. I'd ask the court to consider at least imposing a PR bond. And if the court is not considering a PR bond, to at least do a 10% extra surety bond to allow him to be able to cooperate with me in his defense. I think that him being incarcerated would limit our ability to prepare for preliminary examination in this matter.
And those were some of the questions that I had, Attorney Curtis. Does he have grievances in his record? What does his record look like? You're telling me that there are no prior instances of this nature in his history?
No, I've reviewed his personnel file, Your Honor. I've talked to the people that know him. There is no grievances in regards to excessive use of force at any other point in time, any motor vehicle accident. To this point, as a matter of fact, he received the Gold Award from the Michigan State Police for having 12 years of accident-free at-fault accidents in operation of police vehicles. He is a man of faith, attends church regularly, and he is not a person that I am concerned that is not going to appear or is a danger to anyone.
And how long has he been on the force?
He was a trooper for 25 years. He was 26 at the time that this happened.
He resides in Grand Rapids?
He resides in Ottawa County. We're going to correct that with the court once we were done at this point.
I do have Grand Rapids address on
Yes.
file. And so the things that the court considers are risk to public safety, willingness to appear and stand trial, prior criminal record, and as it is Detective Sergeant Keeley turned himself in willingly, does appear willing to appear and stand trial in this matter, has little to no criminal record, and certainly nothing that leads me to believe that there is a risk to public safety that is representative of the conduct alleged in this matter. I do agree that a personal recognizance bond is appropriate. I am going to set a $250,000 personal recognizance bond in this matter with standard bond conditions. I understand he is suspended from his duties at this time.
A little bit of limbo as to where he has filed for his retirement. The Michigan State Police have released to the media that he has retired from the department, but he was suspended without pay up until the Michigan State Police made that announcement to the media.
And so while this case is pending, you may not leave the state of Michigan. You must update your address with the court and then continue to keep it current with the court. You may not of course, commit any crimes while on bond, and you must show up on time for your court appearances, which are
Keely, look, she's a good judge. That's the only thing I'm saying. You lucky. She's a great judge. Great, amazing.
Security.
But you?
Security.
Thank you, ma'am. June 17th at 1 p.m. is your probable cause conference date. June 24th at 2 o'clock in the afternoon is the date currently set for preliminary examination. Anything further in this matter, counsel?
If I may, Your Honor, given the facts and circumstances of this case and the charge, in discussions with the AG's office, they were expecting me to ask the court if we could enter onto the record a 21-day waiver at this point. So if there is an adjournment down the road, we don't have to worry about putting that on the record at a later time.
And the law and court rules do require that the probable cause conference and preliminary examination be set within certain time guidelines. Mr. Keely, I'm certain that your attorney explained those to you. Are you voluntarily waiving your right to have those hearings held within those specific time guidelines?
Yes, ma'am.
And then we will enter that waiver onto the record. Are you asking to have either or both of those moved at this time?
I think we can do the probable cause, Judge, and let me talk to the prosecution, and then we'll be able to determine whether or not we'll be able to go forward on that date.
All right, please let us know then on the 17th whether or not we need to adjourn the preliminary examination out any farther.